Welcome to this week's edition of the Commercial Real Estate 101 Meetup Group. This is actually a recording from our live in-person event this past Thursday that was talking about zoning laws. We had a really awesome guest who talked about a variety of different zoning factors for, primarily locally here to Louisville, Kentucky, but a lot of what he talked about also applies to other municipalities across the country. And although some of the zoning laws and maybe processes are slightly different, there are definitely a lot of things within this interview that you guys are going to gain value from. His name is Nick Pregliasco, and has done a lot of big rezonings, and conditional use permits, et cetera, throughout our municipality. And, I think that he will provide a significant amount of value to you all who are listening to this or watching this on YouTube. So feel free to check it out, and looking forward to hearing your guys' feedback. So Jeff's going to be joining us here in a moment. So welcome everyone to this month's meetup for Commercial Real Estate 101. We actually started meeting in person, about 2 months ago, if I'm not mistaken. This is our January, so we've been meeting in person. We've been doing a lot of these virtual calls. We've been doing it since 2020, a lot of these virtual calls. So if you guys are watching this on LinkedIn, we've been doing this for a long time. Today we have an awesome guest to talk a little bit about the zoning process, primarily here in Louisville, Kentucky. So if you guys are watching this outside of Louisville itself, it may not apply to you, but it's still certain things that may. So stay tuned and see if it's a good fit for you as well. So Nick Pregliasco, great to see you. We're happy to have you.
Thanks to be here. Glad to be here. But I appreciate it, and it's the first time I've been out to the place here at 1020. It's been really nice, and it's wonderful to see the area. It's really changing with the stadium and all that as well. So, yeah.
Awesome. So typically when we have an interview with someone, we like to learn a little bit more about them. So if you don't mind kind of giving us a little backstory on yourself, I think that'd be helpful.
Sure. Yeah, I born and raised here in Louisville, Kentucky. I went to the University of Kentucky for undergrad. Went to the University of Louisville or the Brandeis School of Law for law school. But I've been practicing for now 20 years. Seems like it's just been a couple years, but it's been a full 20 years, almost 21 now. But I've been doing land use work specifically for 12 years, almost 13. So practicing 21 years, the last 13 I've been doing land use specific work. Before that, most all real estate work as an attorney, handling closings and other aspects of commercial transactions. But recently focused on land use, and it's somewhat of a specialized area of law, specialized because I think no one else is dumb enough to do it. No one else wants to put up with the headaches, but I think it's also specialized not because it's too intricate, but it's more there's a very broad subject area, and I say that because it's you have to have some knowledge of transportation planning, some knowledge of construction, some knowledge of the market, as well as then the land development code in addition. But I've really enjoyed it, and I'm with a small firm, Bardenwerper Talbott Roberts. We're a boutique firm in that there are, I guess, 5 attorneys, but we do predominantly just land use work.
So my question is a little bit more narrow. So what actually got you interested in zoning law itself? So
it's a interesting question, and my family has been in real estate. My father is a commercial broker. My mother was a residential agent, and then our family friend was Bill Bardenwerper. Bill is the one who started our firm, Bardenwerper Talbott Roberts, and I got to know him and kind of follow his, I don't say career, but his experience with different cases. And it really kind of sparked my interest from there. The next logical question is, why did I stay in it? Because it's not it can be not an incredibly thankful job other than for your client. And I say that because when you have any land use case is a rezoning or a development plan or whatever's being proposed that is a change from what's there today. It's different. People tend to not like things that are different, so when we have neighborhood meetings, people that come out are generally to express their displeasure with what you're doing. They want the field that's next to their house to stay a field and all that stuff. But it is also it's rewarding in the respect that you, at the end of the day, if we are successful and a project is approved and ultimately constructed, you can drive by and see the facility, whether you can see the new subdivision that's put in, or you can see the retail development or things of that nature. So I think from that perspective, it's been very rewarding.
No, definitely, and that's interesting to see. And obviously, the work you guys do at your firm is obviously very important for the city's growth long term. So it's exciting to see you do that. So one thing I wanted to kind of talk about was, what exactly does the process look like? So, again, let's imagine that I have a particular use that I want to put on a piece of land, but it's not currently zoned for exactly what I want to do. What does that process look like from start to finish?
Very good question, and I think the first thing that we always look to when somebody comes in and says they want to have a property rezoned, they want to change the use of it. When a person asks that question, they're really asking three things. I think one is, what are the chances of success? Two, what is it going to cost me to go through the process? And then three, how long is it going to take to get through? So when we look at it from the very beginning, the test is the comprehensive plan. Locally, we have a land development code and we have a comprehensive plan. The land development code are all the details, the specifics of what has to be complied with, such as setbacks, building area ratios, things of that nature. The comprehensive plan is the impact mitigation plan. It's adopted every 20 years, but it's almost 100-page book. We just adopted a new one, became effective in 2019. People ask what is in it or explain what's in it, and it's a very simple answer. It's everything's in it, and I say that everything's in it. But if you can think of an impact that a development will have on your neighbor, it's kind of interesting. We have the derby going on. If you can think of an impact that your property is going to have, or your development will have on neighbors or in the general area, whether that's noise, lighting, traffic, aesthetics, building materials, it's all in there. So then our job is then just to try to mitigate that, to try to address the concerns. If they're making the traffic worse, is to then figure out if there can be turn lanes or things added, et cetera. But we look at that from the beginning perspective of it. But then from the process, to answer the question, it begins with a pre-application filing and then a neighborhood meeting. I think the reason that I mentioned that, or it's important, is twofold. Is that the one question I said at the very beginning is people ask, well, what are the chances of success? Is we can give, because we've been doing it for a while, a very high degree of certainty as to whether it would be successful, just from past experience. We also know that within the first 3 weeks of starting, we'll know two things. One, are there any technical issues that we didn't know of or think about? Things such as sanitary sewer service or utilities. And that's all done through our pre-application filing. But then the second thing is we have our neighborhood meeting at the very beginning. So before we file the official application, we have a neighborhood meeting. So you notice all the adjoiners, those in the area, and let them know of what's being proposed and discussed. And then you also, at that meeting, will know, is this something that people are just a little bit unhappy about, or are they showing up in droves and really wanting to fight and that. So we often say, after those first two things, being the pre-application filing and the pre-app conference and the neighborhood meeting, we can then tell with 95% certainty or more whether something's going to be ultimately approved. The reason that's important is it goes to the other issue that I mentioned, and that is, what is the cost? And the reason I say that is because you can figure out those issues at the very beginning. You don't have to go all the way to the end and have the vote of the Metro Council to figure out, is your zoning going to be approved? We often know that early on because of those two things. But then back to the process, once you do officially file the application, then you go through agency review. That agency review is the plan is sent out to the public agencies, and they transportation planning, public works, MSD, all those agencies, and they review it. And only when once you've satisfied all those agencies, are you allowed to go forward. And by that I say going forward, you go to a committee of the Planning Commission, the LD&T committee. It's a technical review for the purpose of scheduling the public hearing, and then you have the public hearing in front of the Planning Commission. But then ultimately, the Planning Commission in a rezoning case is just it's a hearing. That's where all the evidence is presented by us, the presentation is made, and our experts, the traffic expert or engineers. But that's where all the neighbors attend and voice their concerns. But ultimately, that's a recommendation to Metro Council of the rezoning to approve it, recommendation to approve it, or a recommendation to deny it. It's Metro Council unless it's in one of the 12 small cities that have zoning authority. I do mention that because we do have 12 small cities in Louisville Metro. St. Matthews, J-Town, Middletown, even things that Douglas Hills, Graymore, Devondale, things you wouldn't necessarily think of per se. But if it's one of those cities, they would go to one of those cities instead. But the ultimate decision is made by the city, Metro Louisville, or Metro Council, or the small city. But and then back to the very beginning, I was saying, from a timing perspective, it really takes 6 to 9 months. 9 months is probably or 7 to 8 months is probably the best guesstimate. Just if something goes through fairly smoothly and you hit the dates right. If it gets really complex, or a case such as Topgolf, I think we mentioned earlier, or some of the One Park is a case that we're having my law partner has a meeting tonight on the One Park for the new there. Some of those then take longer just because there's more technical aspects of it, but and those could be up to a year. From a commercial real estate perspective, if you're a broker or anything of that nature, we suggest in purchase contracts to have a year contingency. Just being enough time to get through the process, and then always having the appeal contingency at the end. So on rare cases, you do have situations where an approval is appealed, and but then having the ability to continue to defend it or fight that in court is always important as well. So, yeah.
And I think and it may be different in other municipalities or across the country, but here you couldn't just go and say, hey, this land zone, R4 residential, I want to turn it into commercial without having an idea of what exactly you want to put on it. Is that correct?
That's a very good point because it is different in other cities, but it's also different in the rest of the state. But we are a plan certain jurisdiction. You often hear people throw out the term plan certain. I think a lot of people get confused as to what it means because they'll say, what's the zoning of that property? And they'll say C2. Is it plan certain or pre-plan certain? But all it means is that there's a development plan approved with the rezoning. So with the rezoning, you not only the use, which is the zoning district, that would change, but then also a development plan is approved with it. And the development plan is really what provides the detail of how you're going to address all the things I mentioned at the beginning with the comprehensive plan. So, if you're going to say, I'm going to address lighting, noise, screening and buffering, I'm going to address traffic, those things, that's all shown and demonstrated through your development plan. So the development plan is a very important aspect of it with it. So the distinction, plan certain, pre-plan certain just means the property was always zoned that way. It means it was there when, as an example, I live in St. Matthews, close to Shelbyville Road, but if you go down the middle of Shelbyville Road, when we adopted the zoning, those first properties were all commercial, so they are all pre-planned certain commercial or C1 uses. A plan certain is a property that had been rezoned over time. Somewhere along the process, they changed it from residential to commercial, or from C1 to C2, or something of that nature. But it's a very good point because I think the other thing with particularly anybody's interested in commercial real estate, whether you're a broker, investor, any of that, the other thing is if a plan has been approved, it's plan certain, that is binding on the property, and it runs with the land. So people often, when they buy properties, they get a title search. They review the title search in tremendous detail, and they look at all the exceptions. But I've been surprised how many times people don't look at, the development plan that was approved and what are the binding elements. A binding element is a condition of approval. It's just simply when you go through the zoning process, we locally call binding elements conditions of approval, but they are binding on the property and run with the land. So we had a period of time recently, I say recently, in the last 20 years, where we had a lot of use binding elements. They're not favored anymore. There aren't as many now, but it's important because, for example, if you rezone a property to C2, so if you go residential to C2 or C1 to C2, you would, if you go to buy that property, you think, well, it's zone C2. That means what can I use it for? I pull out my code and I say, well, here's a listing of all the uses allowed. But if there's a binding element that prohibits certain ones of those uses, it's important to know that up front, because it's always, better to figure that out. It's something that it doesn't show up on the title itself. Sometimes there are certificates of land use restriction that are put of record that will kind of tip people off that there is a development plan and that there are binding elements, but it's not always the case. But even a development plan, if there is one, you also would want to maybe look at it, make sure that what is physically there matches what the plan shows. Because just because they, I don't say got away with, but they built something that's not in compliance with the plan, and haven't been cited before, doesn't mean that they're not going to be cited in the near future. So we've had a number of cases where clients have come to us and they said, well, I just bought the property. I thought it was fine. And then, I found out that the seller didn't build the second entrance, or he didn't build the berm that was committed and obligated to build. So it's always helpful to know that stuff up front as well.
I know that you named a couple little mishaps that business owners, investors, brokers do in the past. Are there any others that commonly repeat themselves from client to client that you want to elaborate on?
Yeah, so there's a couple things with that. One, if you look at all of the rezoning cases that we have, by and large, those are in two different categories. One are cases where somebody is going through and they have a property they want to redevelop or develop for the first time. It may be a field, it may be a residential home that they want to develop, and they are going through it to make a profit and sell it, or they want it for their use, their business, things of that nature. That's one thing. Then the other aspect, the whole other side of it are enforcement cases, and those are cases where somebody has been using a property that is in violation of its zoning, and that is a case where the use that has been there for some time, it may not be allowed in the existing zoning district. So eventually there would be, often are cited. And they, then have to, go through and file the, application for one of two things. Either you can rezone the property, or you can have non-conforming rights. So there are properties that are ones that don't match the current zoning. They could have non-conforming rights, and they could be valid legal non-conforming rights. That just means that it's been in operation and use since the time it was either the zoning came into effect, or it's been in use since they changed the zoning, et cetera. But it's really the front end is to look at that from the perspective of the question of things people get tripped up on or whatnot. In development, I think the main thing by far in that case is sanitary sewers locally. I mean, in Louisville Metro, it is infrastructure, but predominantly sanitary sewers. And I say that because you'd be amazed at how many times we've worked on cases where there's it's a very large development, and they have a high-profile New York law firm representing the buyer, developer, and they have these huge legal fees and all that stuff, but no one ever sits there and verifies. Well, not only do they have the access to sanitary sewers, And by that I mean, are they directly next to it, or can they get the easement, or they have easements? But also, is there sufficient capacity in the plant? That's a one that has, it changes over time, and that's always important. So the reason I say that is that there are always things to, look at, from make sure you can get the local water service, you can get, your gas and electric, you have your entrance things, but sanitary sewers is the biggest one. And the other issue with that is that the reason that's the problem here more than maybe other cities is because of the fact that just historically we haven't, some jurisdictions, some cities have a belief that if you build it, then they will come. If you build the infrastructure, development will fill in after it. Locally, what happens, and this is both with roads and with sanitary sewer service, really, is that it's built as the development occurs. And so that is, there'd be a area where there's a whole area that doesn't have service. It's on septic system now. And we build it, it's kind of the next property builds, and they extend the line. Then the next property builds, and they extend it a little further. And it kind of goes over time, and it's slow. So we just have a larger area that doesn't have that, with it. The other one is the big two, I guess, would be that sanitary sewer, and then also I'll say traffic, but I mean it's really the traffic management or access. Whether it's a lot of the issues of just that there's bad traffic in the area that can be addressed in many ways, but having curb cuts or things of that nature. For example, if you have a property that's a residentially zoned property and it's on a major road, if it's if it has a driveway today, it doesn't mean you get to keep your driveway if you rezone it, because it would be a different use then. So we've had a number of times where people come in to us and they or get further along in the process and then find out that, wait a minute, I bought 3 houses, all 3 of them have driveways, they're all on Taylorsville Road or Shelbyville Road or these roads, but of course I can have access. Well, no, it all depends on meeting the requirements. So that's the other one to kind of flesh out. But that goes back to what I was saying at the very beginning, and that is when you file a pre-application that's early on, those are the type of things that you can flesh out so that you don't get too far down the road to your ultimate hearing before you find those matters out. And with that, one of the things that it goes to that point, you just asked a very simple question. I keep talking, but sometimes you'll hear people say, particularly project opponents, will say, "Well, the development process is fixed," or because 97% of cases are approved, or I forgot the stat. I mean, it's traditionally more than 95%, but they'll cite it and say that that just shows that it's the Planning Commission is siding on the side of the developers or things of that nature. And the honest answer is that what we do is when somebody comes to us and says, "I'm thinking about zoning a property," there's a lot of them that we say just it's not worth your time or effort. It's not going to happen. So they don't ever file the application. Or we have cases where we think we think we can address the impacts, and they go further along the process, and then we go through the technical review and we find out there are technical issues, and then we pull the project. Or we get to the point, even beyond that, where we find out there's so much neighborhood opposition that it's just our clients bail. By the time we get to the public hearing and then ultimately get to Metro Council making a decision and voting, there's a lot of attrition where the cases that are questionable or ones that wouldn't have been approved are pulled just because we tell clients it's not worth going forward, or they make that decision themselves. So that's just one thing I hear often, and I wanted to mention that it's the good cases are approved, bad cases are denied. It's just the bad cases tend to weed out earlier on in the process.
That's probably a good thing, like you said, because if it has no chance of getting approved down the line, it's better for them to bow out early than having to spend God knows what type of money in order to make it to the end and realize that it's not actually going to go through. So I think that it is a wise decision for a lot of people just to bow out when they do. So one of the main questions I get asked a lot is that there's a lot of people out there that deal in the commercial in the residential realm, but they want to delve into the commercial side, and one of the ways to potentially do it is identifying properties in an area that's surrounded by commercial property. It may be residentially zoned and then rezoning it to some other, commercial use, and they can utilize it for whatever different purposes they want to. Can you kind of talk a little bit about what that looks like, and again, similar to what we talked about, some of the hurdles and challenges that you see when people looking to do something similar?
Sure, definitely. And they, so when people are, there are certain brokers who not specialize, but they really focus on finding development land that's undeveloped that could be developed, in whether it's rezoned or whether it's simply a development plan, or one thing we haven't talked about, but it's subdivisions. And I say that because a subdivision doesn't necessarily require zoning, but what I think people who are looking at properties that are undeveloped, it's to focus on maybe what are the could be the potential issues or concerns. And when I say that as an example, we always say, and I tell everybody here, is that if you're interested in having a discussion about a property can it be rezoned? Is it worth considering? We always talk to everybody. We don't charge people for pulling the information, pulling the prior plan, pulling the binding elements, as well as other cases in the area, and then giving feedback. We don't charge for that, to do that. So because of that, we get a lot of calls, and a lot of them never go forward. They just they're ones that don't move forward. And the reason I say that is because we get calls, and I had one just earlier this week where somebody called and they said, I'm thinking about rezoning this property. It's vacant today. It's I want to rezone it to commercial, and I said, well, the problem is sewers, and you can't get access. And answer this question. He said, why didn't you? He goes, I didn't even tell you the address. I just told you where it was. I mean, the intersection. I said, well, you think that this is the most perfect property, and you're the first person to ever think about rezoning it, or that it would be a great property. So the reason I say that is that we're the becoming a built environment, in Louisville Metro, so that a lot of the properties that I think they're becoming more and more difficult, and I say that because they tend to have more problems or issues, and so a lot of times we will have heard of properties, or we will there'll be certain properties that people think of that to rezone or to develop, and but there is a particular problem with them. So one thing would be is to identify those early on. As far as from a subdivision perspective, the other thing is from Louisville Metro, we're largely a built environment, and I say that because more and more I think you're going to see new residential development occurring in the surrounding counties, maybe the greater Louisville area, but not in Metro Louisville, but the southern Indiana, but Oldham, Shelby, things of that nature. There aren't the huge tracts of land left in Louisville Metro, but if and then even with, for example, we had one time helped create a list of all the potential areas where could be developed, all the lots that would be developed, and almost 50% of them were in 60% of the lots that would be potential development lots in Louisville Metro were in the Floyd's Fork area, and near the parklands of Floyd's Fork, out Talesboro Road, but they don't have sewers there now. So I mean, it's back to that same issue. But the other thing, and then with that is one interesting question that wasn't asked, but it's also directly related to what you're saying. But is we sometimes get the question of, okay, well, what is the hardest thing to get approved in Louisville Metro? What rezoning is the most difficult to do? Is it for a gas station? Is it a assisted living, or you name them? And the honest answer is it's not a rezoning. It's a subdivision. A single family subdivision tends to have the most opposition, the most people that come out. They're most often appealed. They're and those are cases where it is a matter of right. You don't have to. Zoning is a discretionary approval. It's they base it on the comp plan, but they decide whether it makes sense to rezone the property, and it's the discretion of the planning commission. In a subdivision case, it's a ministerial review. It's just as long as you check the boxes, you're entitled to your approval. Those tend to be the ones that have the most opposition, as well as the ones that become the most difficult ultimately, with the longest hearings, most repeat hearings, things of that nature. The reason I say that is that sometimes we have people that we were talking about. If you find a property and say, "Let's be great for a subdivision," and it's a residential subdivision and it's going to back up to a residential subdivision, well, that's a no-brainer. I mean, people think that often, but it's not the case, because then people often look at it, well, our homes are a little bit bigger or nicer or bigger lots, or that's generally what we end up, coming to. And really, and that's related to the market now is small lots. What's changed in the last 5-10 years is now people they still want the big house, but they want a smaller lot. And so the 50-foot wide lots are what the production builders are building. That's what everybody wants. Doesn't mean it won't be an expensive home, but that's what's really in the market, and that's what people tend to look to get approved with it.
I think now we'll open it up for Q&A. Okay, the question is she's has a commercial property and she's got 3 different buildings. It's all in the same plat, but in the rear of the property she has a carriage house, and people have offered to purchase that. So her question was, does she need to rezone that to a residential structure in order to sell that particular building?
The answer is you would not. So in the commercial zoning districts in C1 or C2, or even if you're going in from the residential zoning districts up to the OR, OR1, OR2, R3, then C1, C2, those all allow residential uses, and it's just the density that you're allowed. And honestly, in C1 you can have over 200 dwelling units an acre. So, I mean, vertical, it talks 235 dwelling units an acre, but the design is that you would be able to go for a high rise or something. But so it is allowed. What you would run into there would be just an issue of if you were to subdivide the lot, it would be a minor plat process, minor subdivision plat process, and there it's just as long as you can, I'll say, check the boxes, but where you have direct access. If the carriage house would have to have direct access off of an alley and meet their code requirements, but it wouldn't have to be rezoned. So yeah, so the question that was asked as a follow-up is that if you have a home and then a carriage house, you have to access it through the middle or kind of through the side. Can it still be subdivided? And the answer would be as long you can address that through easements. Even, for example, I mean, what I'm saying that is that even if your direct access is through the front, you can still have an access easement. It doesn't prohibit the subdivision. What would generally be the issue would be when situations like you're talking about is they would, when you create lot lines, sometimes then you trigger situations where you need a variance or waiver. And by that, I mean if you have to meet the setback requirements. If you're creating a new lot line, you can it could change the setback, but it wouldn't be prohibited. And to that question is something that's a broader question, and that is, in Louisville Metro, there is always a topic of the day. And I say of the day or the year, or et cetera. It has been trees for the last couple of years. We had a new tree survey that was done just recently, or updated. And it seems like we're making ground. We're not getting worse. But the new one is the missing middle housing. That's they call it missing middle, but it's anything from a duplex to 50 units. So it's not single family, and it's not a large apartment project. It's the duplex to 50. So there's been a real push to allow those as a matter of right in different zoning districts, as well as even beyond their pushing to have the carriage houses or mother-in-law suites, however you refer to them, as a matter of right in single-family zoning districts where they would previously have required rezoning. So that what you're talking about as far as having a separate dwelling unit in an accessory structure behind the main structure is not only one that's honestly being promoted and even changed to a matter of right in some cases as well.
Any other questions we have pertaining to? You got one? So the question that was asked was pertaining to short-term rentals. So here in Louisville, the area that he's talking about is along a major highway. It makes sense to rezone to commercial type of use. It's currently zoned residential. He wants to switch it to commercial, but he was wondering if there's something more specific that targets just short-term rental usage in the city. So.
Yeah, it's a good question, and I'll give a little background and answer your question at the same time with it, but because there's really two options. So with the short-term rentals are Airbnb. It could be VRBO, you name it. Those type uses. Short-term rental is anything 30 days or less. And I know you know this. I'm just providing more context for people who may not. But so a short-term rental is if you want to have the ability to rent a space for less than 30 days. And every city does it different. And when this occurred in Louisville in the last 5 years, there's a lot of discussion of how's Louisville going to address it. The idea of a short-term rental. So if you have a short-term rental and you reside in the home, you want to rent out a bedroom, or you're going to be your residence, you can do that as a matter of right. Now, if you don't live there, you would need a conditional use permit, and so that's one avenue of dealing with the issue that you're talking about. The rezoning being the second, which I'll talk about in a second. But so conditional use permits for a short-term rental. What happened is we adopted locally our conditional use permit regulation, and then there weren't many filings. I mean, people didn't. You look at the Board of Zoning Adjustment, a conditional use permit is a case that goes to the Board of Zoning Adjustment rather than the Planning Commission. But you didn't see many of them. And then we would get calls for people, and they would say, I got cited for renting my place for a short-term rental, but, they told me to go through the process. So the only penalty was for not complying. So if you're begging for forgiveness, not asking for permission, the only penalty was they made you go through the process. They eventually got to where they, about 3 years ago, got to where they got Airbnb to require the approval to put it on their system. And then all of a sudden we had a floodgate, and it seemed like at that point the Board of Zoning Adjustment dockets went from 7 cases to 20 cases, and it was just an inundation of short-term rentals. And I am answering your question. It's been a long way of getting there. But what I'm saying is because of that, there was an overreaction. Not overreaction. There was a pushback on it. So now, if you have a short-term rental for a conditional use permit for a short-term rental, there is a 600-foot rule. It means if there is an approved CUP for a short-term rental within 600 feet of the property you own or you have it, then you're not allowed to have a short-term rental CUP unless you get a waiver or forgiveness from that. They call it a waiver, but it's not a traditional waiver. It's a relief from the requirement. That's become harder and harder to do. The idea was they don't want certain areas, whether it's like certain parts of the Highlands or, if you look at the map of all the approved short-term rentals, almost all of them are inside the Waterston. So, it's more of the traditional neighborhoods. They didn't want clusters of them, so they had the 600-foot rule. So the other option is a rezoning, and that may be what really works well potentially in your case. Now, a rezoning would be a short-term rental is nothing different than a hotel or a motel. I mean, it's the same zoning, districts. You would allow that, whether it's an OTF, office tourist, or C1, C2. I mean, those zoning districts would work for those. And if you have multiple units that you want to lease, then the rezoning is the way to go. So what I'm saying is if you have for example, a duplex, and you want to rent both of them, and you want to have both of the units be short-term rental, then you would need to go through the rezoning. If you had a building that you wanted to be an apartment building where there'd be a 10-plex, and you wanted to have every one of those as a short-term rental, you would need to go through the rezoning. And as far as the zoning district to go to, it would be what we always suggest and what's always really required is the least intensive zoning district that allows what you want to do. So that would either be the OTF or C1, most likely. But and then it's just a matter of does it have any other issues that may come up with setbacks or things of that nature? I don't know if that answer your question. Yes, and I can just give you my card afterward and show you. But it would be basically the hotel or motel use. So if you look into the land uses, so if you're explain is if, for example, the way our code reads is if you take C2 as an example, the C2, it says if you go to the code, it says here are the permitted uses, and then there's a list of 20 or 30 uses. And then the very first one is all the uses in C1. So what happens is It's so if you are looking at it, you would generally would have to do is you kind of have to look at C2 and then go back to C1. But it's the hotel or motel use would be the defined or delineated use that you'd be looking for, and that would be the described. And it's just really anything that's less than 30 days would be the what would be the kind of what's allowed. And there's now more people talking about having these, particularly down in this area, really the Nulu area as well as the downtown area, of having developments where they're built as short-term rentals. If you looked at them, you would think they were an apartment project, a apartment development, but they're just not going to be. They would be all on Airbnb and that. And the idea being is that would be a rezoning, but then you could also buffer and screen and deal with the issues. You tend to have a little bit more scrutiny. But then to answer the next part of the question is just a conditional use permit is quick, and that is that you file your application, have your neighborhood meeting, and they docket you for your Board of Zoning Adjustment date. It can be, you could, from the date of filing to your date, you could be 5 to 7 weeks. I mean, from start to finish. The rezoning is more involved, costs more money, and you're talking about the 6 months or 6 to 8 months process. So and you have to have a land planner engineer. It just becomes more involved. But it makes more sense. Rezoning makes more sense if you are looking for potentially more than one unit, being rented as short-term rental.
And then I had a quick question pertaining to the value, and again, more so on the value side. So, given the fact that some of these higher zone properties have more uses that fall under them, does that also increase the value of those different zonings?
Yeah, I think so. I mean, inherently, they from a perspective of appraisal value, or what is the value of the property, a commercial zoning is more valuable. Now, I always, people sometimes ask me, and I'll say, they'll ask me about a property, and I'll say, okay, it may be zoned commercial, it may be zoned C2, but from a practical perspective, you can't do much with it for these reasons, and it may be some of the ones we talked about or whatever. But, it doesn't mean necessarily that it's inherently worth more or more. But I know for a fact that it will always be worth more, or considered to be worth more, because when they start to, if you're getting appraisal and they do comps, they'll use commercial comps versus, the residential or the lower zoning district, comps. So it always is viewed as that. We had even a case where we were purchasing a large development, and there was surplus right-of-way next to it. The state had surplus right-of-way they didn't need. So we had it, the client said, well, I'd like to acquire it. I'd like to buy this extra strip of land because it actually really helps my development. We went through the process, and we were the surplus process. They designated it as surplus, and they had a appraisal done, and they said the property was worth $12,000. It was a strip that was only 10 feet wide and real minor. They said, well, it's worth $12,000. And they said, then they came back and said, wait a minute, we didn't know this was going to be added to your development. We said, yeah, it's going to be added to it. They said, okay, well, it's $670,000. We said, wait a minute. It was $12,000 a minute ago. Now you're talking, and we're not talking about rezoning it. What they had done is the appraiser had then gone back, and this was actually, what I'm talking about was a student housing development in Old Louisville, but it was right by 65. And they determined, the appraiser actually astutely determined, he said that without this strip of land, this developer was going to lose X number of apartments. And no matter what, they could not fit. But by having this little strip of land, they were able to move it, and I don't remember the number, but it was very significant. They just said, well, so that's worth to you $670,000. But it goes partially to your point is when they look at it from the perspective of just the residential zoning, it's not worth as much. But when they look at it from the perspective of whether it's rezoned or just used in connection with a developed zone property, it's worth more, and it can be worth quite a bit more, really.
So, is there any more questions? No? Okay. I know everybody's probably going to have questions once they go home, and people that are actually viewing this live and later on. How can we get in contact with you if they have any more questions?
Sure, and feel free to call us anytime. It's Bardenwerper Talbott Roberts is the law firm. It's bardlaw.net, so BARDLAW.net is our website. It has our information. Phone number is 426-6688. But I also, like I said, I tell people all the time to contact us if you have a property you're interested in possibly rezoning. We don't charge to give advice. There have been days where I feel like I spent the whole day doing nothing but telling people, giving free advice to people, telling them that the project may work, may not work. A lot of times people come back later. The reason I say that is that if you have the information that you may be able to find, but it may take you a little while longer to find, we can do that really quickly and send it to you. So our emails are on the website as well, so feel free to contact us, and we're happy to give that advice. And also, there's sometimes where we have situations where people ask us, thinking about rezoning this property for this use, and we will come back and say, well, it doesn't really work for these issues, but here's a great use for it. Just a different is not necessary. And we may even know people that are interested in, looking for property like that. My point is that just because there's a problem doesn't mean it's insurmountable or it can't be overcome. It just may be a little bit different than maybe was originally proposed or thought of.
Yeah, we'll include that in the show notes. If you guys are watching this live, it'll be in the description below, so you guys can get in contact with him. And I can attest to their advice. I've actually had a meeting with him before for one of my clients who was looking to rezone a piece of property, and he provided great advice, sent emails and everything too. So we didn't end up moving forward with it, but ultimately it was good advice, and it helped us save a lot of time. So, which is the ultimate point. So, again, thank you all for stopping by. We do this once a month, the third Wednesday of every month. So feel free to stop by. We're going to be hanging out and just talking. So great to see you all. Great. Great job, yeah.